Ah, jeez. All day long, man. All day long. Please tell me y'all can hear me. Please tell me you can hear me. Holy cow. Mommy Spice, how you doing? Lefty, what's happening? Rabbit, how are you? How are you? Um, Charles LePage, hey, how you doing? Hang on, let's see here. I've got you on the living room TV. Tell me what this is about. I'm ready to be law splain. So, today was the there is no music. There should be no music. I hear no music. Oh, never mind about the music. I'm on hold with CVS. That is the greatest thing I've ever seen. That is the greatest thing I've ever seen. Thank you. DJ Lewis, how are you doing? Um, Zena's Scholler. I thought there was a C in there. I apologize. How are you doing? Okay, Fire Nights, how are you doing? Even though I never did get in the gym, I have a blister on the bottom of my foot. At least I really made it to the stream on time. That's awesome. Well, this is a weird time, okay? And the reason why is because today's I had no idea this was happening today. It was I woke up to it. The Nick Rekieta, Steve Quest, better known as Monograph, Appellate Court hearing. All right. So, man, this thing, why is this thing so fuzzy? Everything's messed up. Almost knocked over my milk. We wouldn't want that now, would we? Anyway. Jeez. So, I I mean, I'd have to sit down and I don't know, I'd have to have like a whiteboard to explain everything that's happening in this case. Jackpot Springs, how you doing, bud? I haven't seen you in a while. Um, anyway, what it is that Monograph is suing for defamation. Okay, you gonna leave that there. Hey, cool gamer, how are you? Um, Dave Umberger, yes, yeah, I did too. But now we get the whole clean video of it, courtesy of our friend Alyssa Clips. She had it up. I was like, oh, thank goodness, I don't have to go find it. So I told her that I'd be saying that she is cool, and she's always been cool to me. Um, but she doesn't return my messages. Does that sound familiar? Shinnygram, how are you doing? So glad to see you back. I think they both should have left it alone. Well, then that's when you're supposed to say that you're just here to smash the like button. Smash the like button. Texas Jam, what's happening? So what? So I woke up, same thing. Saw this was happening today. I was like, oh, cool. Try to get this stream out this afternoon. I was like, boy, this is the first time I ever did Zoom. Zoom sucks, man. It takes over the entire computer. Lost control of microphone, lost control of speakers, everything. Jeez, I spent too much time afterwards trying to figure that out. Hey, just Don, how are you doing? But here's the thing. So Monty is suing Rekieta, right? We all know this. Rekieta's lawyers are doing a Hail Mary pass. I can't believe they're doing this. Okay, I'm going to give you guys my opinion on this. I usually just try to just stick with the facts. Tonight's a weird one. Because tomorrow is February 29th, and I decided tomorrow is going to be the day that I have drama. We're going to have drama stream tomorrow. I don't know what that means yet, but I was like, it's a bonus day. It's bonus day. I just thought that 2 seconds ago. So, drama. This is going to be the prep for it. My opinion is, okay, it was dumb to do this. I'll tell you why. Because There's a Hail Mary pass that the courts are going to see it. Rekieta's attorneys have argued before. This is all what I remember hearing off stuff. You guys know how my memory is, so don't hold my feet to the fire on this. That I did say hey to you, right? Just on. I really love Just on her and Libby and all these people. I love all you guys. But anyway, Gutter, how you doing? Gutter, I was so happy I was finally able to send people your way. So what happened is anti-slap laws and all that stuff's happening, and anti-slap is basically like it makes it harder to sue somebody for defamation. You have to have a criteria set up. Every state has different. The legislature of every state has different things. Minnesota had one. Minnesota's court struck it down. But Colorado has one, and supposedly that is where Monograph is from. Today in is it potentially criminal? Practically criminal? Potentially? I always mess up people's names. I like avatars. Anyway, he said that Monograph was in there. If that was the real Monograph, said, why aren't they trying to apply this to Illinois? Why are they going after Colorado's? I don't live there. I live in Illinois. So there's a bunch of problems with this whole thing. But the main thing is that even if Rekieta's issue, he wins on this issue, that they're going to apply Colorado law and toss, whatever. It doesn't get rid of the suit. That's what potentially criminals talk about. He's still going to be liable for defamation. He can be liable in Colorado. Perhaps. This is all about venue. And they're talking about venue shopping. When you go to, now this is law school 101. This is 1L stuff, okay? When you sue somebody in their home county, those courts have jurisdiction. You have availed yourself to the laws and the rules of the court, the local court, okay, as a plaintiff. The defendant can't say, oh, well, the plaintiff doesn't live here. I shouldn't be held responsible. They came to your county. So it's a, hey, J. Marie, how are you doing? Yeah, you're totally welcome, Gutter. Gutter, you're a sweetheart. The guy with the pool table, he was a pretty cool guy. Anyway, so here's what I'm gonna do. Just gonna go ahead and get this one started. Boop, not the right one. Nah. Where'd it go? There it is. All right. Now we got closed captioning on here so we can follow along with the words. I'm gonna try to get this cranked up as loud as I can.
West versus Rekieta, and please feel free.
You guys ready for this?
Correct my pronunciation of the last names. The case number for that case is A23-13.
Hey, Mrs. Meg, how are you?
Counsel for that case would approach.
Guys, if new people come in, I'm just going to pull up the thing to say hey. And everybody can hear this right, correctly? Everybody can hear?
That would be fine.
Would be undignified, normal. Thanks.
Good morning, counsel.
Morning.
We good?
As I'm sure you both know, you'll each be given 15 minutes for your argument this morning, and appellant, you'll be given 5 minutes for rebuttal. If you could both, before beginning your argument, identify yourselves and your client for the audio record. And the bench is adjustable, so feel free to take your time adjusting the bench prior to beginning your argument. So with that, Counsel for Appellant, if you're ready.
Thank you. I am Mark John Randazza. I am here for the appellant, Nick Rekieta. I am with my co-counsel, Matt Kazaya. And with that, may it please the court. This case is about an internet celebrity beef ongoing for about 5 years. But this appeal is about predictability, consistency, and discouraging forum shopping. After years of back and forth nastiness by two men who proclaimed themselves to be jokesters, this very unserious beef has become a libel tourism trip to the Minnesota courts. To embark on this trip, Mr. Quest, or as he's also known, Montegraph, or October Rains, or any number of aliases, picked through the party's juvenile back and forth banter and found statements that were void of necessary context might seem a bit out there. But in a defamation case, context is everything. Now, the law requires that a trial judge view the existing evidence at summary judgment through the substantive evidentiary burden. Now, today, this did not happen before, and today you have the task of deciding if Minnesota wants to depart from the nationally preferred framework to become a libel tourism destination. In a multi-state defamation case, the presumptive choice of law in most states is where the plaintiff's reputation is, because that's where the plaintiff's reputation is based, is a creature of that plaintiff's state law. The lower court incorrectly presumed that Minnesota law applied, but that was flawed from the start. It began with a flawed observation that if she applied Colorado law, the Colorado anti-SLAPP law is much more powerful than it really is. She presumed, I believe, that it would have foreclosed the claims altogether, when it really would have just changed that prism through which she has to look at the facts and the substantive effect of them on the law. Because the lower court said that the Colorado law gives immunity to Rekieta statements. It may, but it's far more complicated than that. What it really does is it requires that he show a degree of minimal merit. It's perhaps a very anemic qualified immunity, not a blanket immunity. Now, the factors that we should look at, there's really kind of a split in Minnesota, it seems. Some cases look at this Milkovich test. Others look at the Restatement 150. I believe that you get to the same result no matter which one you look at, and I would suggest that this court adopt Restatement 150.
Are you aware of any Minnesota case law that used the most significant relationship approach to resolve a choice of law issue in a tort case like this one?
Like this one, no, because this one is,
Or
frankly,
any tort case outside? I mean, it seems like you rely heavily on criminal cases.
I believe we briefed one, Your Honor, but I'd be lying to you if I said I had that citation at my fingertips right now. But if we look at it through Milkovich anyway, I think we get to the same place. First, we have to look at predictability. Well, applying Colorado law is going to serve the principle of predictability. The principle here is the case should be the same no matter where it is filed, and that's to avoid forum shopping. That's what your Nodak case says. So if the case would be different if you file it here or there, well, then we have this factor in our favor. The nationally approved approach, the one Quest asks you to abandon, flies in the face of Nodak's instruction and creates a perverse incentive to any resident of the 35 anti-SLAPP states to come and file here.
But doesn't the first factor rely on the expectation of which law would apply? And in this case, why would it have been expected that Colorado law would apply? I mean, you started out your remarks by pointing out concern about injury to reputation in Colorado, but you also said that both of these individuals are internet celebrities. So
Yes.
isn't there notoriety really everywhere?
Well, if their notoriety is certainly everywhere. But if Mr. Rekieta were to go to another state to have his reputation taken care of, it would still be a matter of state law. It's essentially, if you have a building in another state, you're going to expect it's built to that state's building codes, not that it would be a different building code no matter who visits it. I mean, that's probably the closest analogy I could come up with. But your reputation management law, your corpus of that body of law, is created by your home state. Remember, Colorado has a different standard for defamation than Minnesota does. Not a very big difference, but enough of a difference that it could change the outcome.
Does it though, in a situation like this, when we're talking about what Minnesota considers to be defamation per se, but really an allegation, or at least as you said, an insult that Mr. Quest is a pedophile? Isn't it true that under Colorado law, that's a matter that would be considered a matter of public concern that would lead to, under at least the case law applying the anti-SLAPP statute, this heightened pretrial burden of proving by clear and convincing evidence, which was exactly the concern that led the Minnesota Supreme Court to strike down Minnesota's anti-SLAPP statute?
I could not have written a better question to illustrate the point. That's excellent. It's no. The Colorado anti-SLAPP law does not have a clear and convincing evidence standard in it. It is simply...
It's not in the statute, but the cases apply it even as recently as 2023. Colorado cases do.
So do your cases. All cases, in fact, since Anderson versus Liberty Lobby, when you're dealing, and that's a Supreme Court case, when you're dealing with a public figure in every state to be consistent with the First Amendment, you must show that a reasonable jury could come to the conclusion that you had superseded that clear and convincing evidence of actual malice standard. So yes, it can be somewhat confusing because there were the old Washington statute and the old Minnesota statute required the plaintiff to show clear and convincing evidence of defamation. That's different than saying a reasonable juror could overcome the Bose standard, the Anderson versus Liberty Lobby standard laid down by the Supreme Court, that a public figure plaintiff must show by clear and convincing evidence that the actual malice defense has been overcome.
Counsel, I want to follow up on that. So, and you raised the Washington statute, which, like Minnesota, anti-SLAPP statute, had been struck down. But unlike Minnesota, Washington then revised their anti-SLAPP statute and appears to incorporate at least 3 different ways that it can be knocked out. In other words, summary judgment, motion to dismiss, failure to plead sufficient facts, which are commonly used as, if not rule-based, statutory-based method, accepted methods to dismiss cases.
Yes, Your Honor.
If I understand your argument correctly, are you arguing that the Colorado statute, unlike the Minnesota one, utilizes, based on case law interpreting the statute, a summary judgment standard, which would, at least on its face, would appear to be an appropriate standard that would not take away the fact-finding from a jury?
Correct. LSS versus SAP, 2022 Court of Appeals 123 from Colorado, says very clearly, The court does not weigh evidence, nor does it resolve conflicting factual claims when looking at the anti-SLAPP law. But it's not just the anti-SLAPP law that we have to look at. We also have to look at the full underlying body of Colorado case law. I believe that you can have statements in Minnesota that, frankly, Minnesota might be too civilized to tolerate, that would be tolerated in Colorado.
Okay, so I probably should have stopped that right before that last sentence. The part that gets me is he is asking the court here in Minnesota. This I want you guys to this is where I put emphasis. Is he's asking them to learn and apply Colorado law. They didn't take the Colorado bar. I mean, I don't know, maybe some of them did, but these guys are not. They're just Joe Schmo in Colorado. They're nobody special. They don't know the law. And I'll tell you something else is the further west you get, the laws they get more and more different because in the East Coast it's much more common law. It's a weird thing how the laws are. And so like when you do want to use a persuasive law, you always want to use one that's close to the state that you're in. I know that why they're trying to use Colorado. But still, you have to learn. You're trying to apply something. No matter what they apply to it, Colorado it's not going to apply in Colorado. No matter what Minnesota decides, it's not going to apply back in Colorado. So why should anything in Colorado apply to Minnesota? Think about that when you hear this, okay? Don't think of it as like this is dicta and this is the way it's supposed to be.
In Booker versus Roberts, for example, at the Colorado Supreme Court, it's 198 Colorado 1. I mean, as far back, that's from 1979. It's even much older than the anti-SLAPP law. Approves of abusive statements that are outbursts of anger. And I'm not going to repeat what they were there unless you order me to, but they would certainly be indelicate anywhere and might be defamatory in Minnesota. But in Colorado, the Colorado legislature and the Colorado courts have looked at their citizens and said, we're going to balance your reputational management rights and your First Amendment rights differently than Minnesota does. Now, that's certainly Minnesota's right to do that. But what you don't want to create here today, I don't think, is a Coloradan seeking an unfair advantage in a defamation case by coming to Minnesota to get a result he could not have achieved at home. He should at least have, theoretically, if we have cloned the two judges and put them on two different benches in two different states, that you'd have the same outcome. Colorado law is the law that should govern that decision-making process. So not just do we apply the anti-SLAPP law, but even if, let's say that you remand it with the lower court's instruction to apply the Colorado anti-SLAPP law and apply Colorado law. She could apply it. She might. I can't predict exactly what she'll do. I'm confident she would find that it eliminates this case. But she might say it doesn't fit the anti-SLAPP law. However, consistent
Hasn't the district court already ruled that if this is a summary judgment standard, that summary judgment is inappropriate at this stage because discovery hasn't commenced? And how does that decision interplay with the application of the Colorado statute?
Again, you guys must be spying on my outline because this is
I'm still muted. I know. Thank you so much. I'm so bad at this. Anyway, what I was trying to say was what she just did was great. That judge came in and just completely went in to throw him off. This attorney does a great job recovering. That's when he said, like, oh, are you spying on my outline? He's very comfortable in front of the justices. That's a good thing as an attorney. But her question, she completely shut down everything he's talking about, Colorado and everything else, to just go back to the very basics here. And see, I don't really realize now they're not talking about Colorado. They're not talking about that anti-SLAPP stuff. This is, wait a second, is it wrong to call for summary judgment? Because the lower court said we haven't had discovery yet. Think about that. What if this thing got, because we don't know when the opinion's going to come out, but what if the opinion came back and it said, yeah, you got to go to trial first before you come to us? All right. I'm not going to try to talk anymore because I can't operate the mic.
This nails the issue right there. That what she was doing was applying Minnesota law to that. So yes, under Minnesota law, her decision may have been correct. I frankly, I don't think it is, but let's presume that it is because her summary
Because
judgment.
Minnesota's procedural rules would apply. You don't disagree that the Minnesota procedural rules would apply to this
Oh,
proceeding?
they definitely would apply. So that's why I don't think that the Colorado anti-SLAPP laws, stay on discovery, for example, would apply in Minnesota court. Only the substantive rights come into Minnesota.
And so respondent would still be entitled, even if we agree with you, respondent may still be entitled under Minnesota's procedural rules to have additional discovery prior to a hearing on this motion. If it's true that the anti-SLAPP is applying a summary judgment standard, and in Minnesota we say you're entitled to discovery prior to summary judgment.
If that discovery would change something, yes. But when we're looking at simply matters of law, it's a matter of law whether someone's a public figure, and I think we've established that. It's also a matter of law if, for example, the level of rhetorical hyperbole here would be tolerated under Colorado law. Her decision was flawed in looking at summary judgment because she failed to look through the prism of Colorado substantive law. Colorado substantive law gives a wider berth to speech than Minnesota substantive law in this circumstance.
Counsel, I want to follow up with, on Judge Larson's excellent question, because what would happen if Colorado substantive law applied? In other words, even if the special motion to dismiss under anti-SLAPP law had been presented, wouldn't there be the possibility to argue, wait a minute, that's premature, because if that is indeed Colorado's equivalent of a summary judgment standard of review that applies, we need to have discovery first before a decision is made. In other words, would Colorado's substantive process, well, procedural and substantive process, be the same as Minnesota's?
The procedure would be different. In Colorado, there's an automatic stay on discovery, which I have not argued would apply here. Here, you would have a presumptive right to that discovery, but upon facing a summary judgment motion, let's say I'm arguing that he's a public figure here, and here it all is, there's no discovery that's going to change that. The only discovery below that they said that they needed was discovery on Mr. Quest's medical records, which I presume he has. So what, if they need that, why did they not get that before? You know, you frequently find, this is pretty much all I do. And I always find when someone's trying to end this case early, the answer is we need discovery. And then the question is, well, what do you need? And the answer is we need discovery. It's just a circular argument. But, in federal court, for example, Rule 56D, you have to at least say what it is you need. And that is I think that's the standard. I'm sorry, I'm just going to plead ignorance on Minnesota procedure here. I'm not from here, but every state that I've been in, there has been a 56D equivalent where you don't just say, I need discovery in some great universe of that concept. You say what you need. Well, what is it you need to show that this isn't rhetorical hyperbole under Colorado law?
You can't go on a fishing expedition.
I don't think you can, no. I think you have to have very targeted and specific discovery when you're faced with a summary judgment motion, whether it's under the auspices of the anti-SLAPP law or simply under summary judgment. Thank you, Your Honors.
Thank you, counsel. You'll have 5 minutes for rebuttal. Counsel for respondent. Feel free to adjust the podium.
Is there a trick to raising it?
There's a,
Button doesn't seem to be doing anything. Oh, there we go. Good morning, Your Honors. May it please the court, my name is Christopher Bowman from the Office of Madigan, Dull, and Harlan, and I'm here today on behalf of Respondent Steve Quest. The sole issue before the court today is relatively straightforward. Did the district court err by applying Minnesota law to this dispute rather than subjecting this claim to Colorado's anti-SLAPP statute? Minnesota's choice of law framework is based on consideration of what all today call the 5 Jepson factors: predictability of the results, maintenance of interstate order, simplification of judicial task, advancement of the forum's governmental interests, and, if still undetermined, application of the better rule of law. In this case,
Do you think Minnesota law is clear that that's the correct test that we apply to the application of substantive, whether this substantive law should apply in Minnesota? Do you think the Supreme Court has clearly said that that's the correct test?
I do think.
I read I think it's Castillo-Alvarez case. I don't know if the Supreme Court has clearly stated anything in terms of what our precise choice of law test is, but.
I don't know, as I stand here today, I'm not aware of any Supreme Court case law that directly articulates that in a tort context. This court has said that in the Lohman versus East Grand Forks case. I recognize review was granted, but subsequently vacated by that. So I think it is established that the 5 Jepson factor test is the controlling framework here.
Under our court's precedent.
Correct. And in this case, not necessarily in every case, but in this case, that 4th factor, protecting Minnesota's governmental interests, Minnesota as the forum state, so overwhelmingly supports application of Minnesota law as to be, in essence, determinative, compelling affirmance of the district court's decision.
Counsel, I have a concern about that. You argue vociferously in your briefing that that is outcome determinative, but aren't we supposed to look at the 5 factors and the 4 factors in particular and have an analysis of each one versus just saying, oh, this one factor controls the whole analysis, so you don't even need to look at the other ones. This one.
Okay, we should be on right now. So, in an appellate court, a lot of times, like, for instance, like the U.S. Supreme Court, that's the ultimate appellate court, right? So, those justices have usually made up their mind, or at least a few of them have. And when they ask you questions, they're asking you questions. So when they go back into chambers and they sit around, they talk about how to rule on a case. They are trying to persuade other justices to see it their way. So when you had the woman judge came in and said, "Is the Supreme Court really clear on this? Is this the way we're supposed to do it? The JEP test, or whatever it was?" And then she answered the question for him. She goes, "Because I read it and I don't think it's clear." So she wanted that out there. Then you have this judge comes in and says, "Well, in the 5 qualifications for the 5 points of the test, well, you have to have like at least 4 of them." And so so what I think is happening here, you're hearing 2 justices kind of arguing their points about one thinks that this is not a set standard and one does think it's a set standard. I don't know how this applies here to this case. I just picked it up and I wanted to prove that I knew my microphone. I knew how to make my microphone work.
This one is the nail in the coffin.
I want to make sure I'm understanding where you said the 4 in particular. Do you mean everything other than application of the better rule of law?
Correct. 1 through 4.
Yes. Again, I think it's a balancing of the at least those 1 through 4 factors. And here, factor 4 weighs so overwhelmingly, and I would submit that the factors 1 through 3 either similarly support Minnesota law, or for the simplification of judicial task is probably neutral. But I don't believe that any of them support application of Colorado's law. So, if you look at 1 through 3 being either neutral or leaning application of Minnesota law, and number 4 being overwhelmingly supportive of applying Minnesota law, I think you reach the same result.
So
Oh,
go ahead.
Sorry. Wouldn't you agree that generally the presumption is the choice of law is where the plaintiff resides, and generally the plaintiff files in their own backyard?
I think, Minnesota and federal law gives plaintiff the option to choose the forum, subject to, of course, jurisdictional and forum nonconvenience grounds, which isn't what we're here on today. And then you go through the five, or really here, the four Jepson factors. And I think you need to look then at, there was a lot of discussion this morning about how Colorado's statute out of the LSS case incorporates the summary judgment standard, and a suggestion that affirming the district court's decision and finding that Colorado's anti-SLAPP statute is inconsistent with Minnesota's Article 1, Section 4 right to a jury trial flies directly in the face of Leyendecker.
Counsel, that's not an answer to my question, though. with
I
all due respect.
apologize, Your
Yeah,
Honor.
my question was, isn't it true that generally there's a presumption that the choice of law is where the plaintiff resides, and that generally the plaintiff files in their own backyard, which would be, in this case, Quest's backyard is Colorado?
I don't know if I would say that generally the plaintiff files in their own backyard. And as for, is there a presumption that the plaintiff's domicile controls the forum? Again, I think is inconsistent with, again, the Lohman case, where you have a North Dakota resident injured by a Minnesota resident, in that case injured in North Dakota, and this court said, it doesn't matter, we're going to apply Minnesota's immunity statute.
Well, let me put it this way. I mean, my private practice is mostly federal, and we almost always filed in the plaintiff's backyard. I mean, it's very unusual for a plaintiff to file in the defendant's backyard. You want to be in your state. You don't want to have to incur the cost of travel. There's an assumption that the jury is going to be more favorable to you, and you don't file in the defendant's backyard unless there's a really, really, really good reason. For me, just speaking for myself, the first two factors incorporate the whole forum shopping. You want to avoid forum shopping. This looks like forum shopping when you file in somebody else's, in the defendant's backyard, because of the choice of law, because of the anti-SLAPP law being held unconstitutional, and so there is no anti-SLAPP law in Minnesota, which would be much, much more favorable for the plaintiff here, Quest. Why, under the first two factors, why doesn't that favor then Colorado because of the overriding goal to avoid forum shopping?
I would respectfully disagree that this is an existence of forum shopping. Speaking to my former practice, where I practiced in railroad litigation, no, we didn't file every case in Dallas-Fort Worth when we were suing BNSF, but where the tortious conduct occurred was controlling. And here, Minnesota is not only defendant's backyard, it's also the forum where at the very least, allegedly, and I think, as the court correctly found, defamation per se, in fact, happens. I think you raise an interesting question of where the harm occurred, because the harm here, unlike the Northwest Airlines case in which the defamation had been submitted in a newspaper, local newspaper, it had subsequently been republished in Texas, but the focus was on the fact that it occurred in the local paper. Here we're now in the 21st century. The defamation occurred on the internet. So how does that play into it? And does Northwest Airlines case even apply, or should we really be?
Okay. Do a little brain exercise here for you. So where does the damage occur? Right? So like imagine if it were a car accident or something like that. I mean, you have a physical thing there, you know where the damage occurred. We're talking about like it happened in a local newspaper, but yet another newspaper in Texas did pick this up for whatever the Northwest case is. The legal system is very slow in adopting technology. Okay. They're probably like 10 years behind where technology actually is. Like, gosh, I mean, everything was fax machines 5 years ago, and now, I mean, still fax machines. It's unbelievable. Does the fact that Rekieta sits in Minnesota, his computer's in Minnesota, his modem, his router, his microphone, his internet service provider are all there in Minnesota. Every means of publication is there. Would that have an effect to jurisdiction? And these are, I don't know the answer. I mean, I'm not I'm not a judge for that. But these are questions that you're asked in trying to figure out how jurisdiction works. And like I said at the beginning of this, everything I understand, there should be jurisdiction in Minnesota. This is the right court.
Be looking at the restatement that, looks more at, the significant, I always forget the name of the significant relations test.
I think, again, I would submit that this court has established that you don't look at the significant relationship test. Minnesota, to my knowledge, has not adopted that standard here, and that Minnesota applies the five-factor test. To your question about does Northwest Airlines apply in the 21st century with simultaneous publication, not only nationwide but worldwide, I think also questions then predictability of the results. If in Northwest Airlines, where a statement is made to a local newspaper before local newspapers also published online, I think that in that circumstance, predictability of results leads to a favoring of where the newspaper is published. Now, where you have simultaneous publication globally, predictability of results becomes much harder to square there, because if this statement, there's a suggestion that because this is submitted over the internet, there's then a predictability of Colorado. But to Judge Eid, your question, assuming without conceding today that both of these individuals raised to the level of internet celebrity, that reputation exists beyond Colorado. That reputation exists potentially globally. And then when you have a predictability question, it throws the whole thing into chaos a little bit.
And I tend to agree with you on that. I think it does, which I think makes Northwest Airlines a little maybe outdated. And so this court and the Supreme Court have relied on the restatement for when we're really entering into new areas of law. Isn't that what we're really doing here? Isn't this kind of uncharted territory that we're entering into? And if so, shouldn't we look to the restatement and what other courts have done as persuasive authority?
I don't think the court needs to go that far in this case. The court certainly could. But here, where again, I think the question before the court is whether or not the district court, and this court is an error correcting court, it has a limited scope with that. And so if Minnesota were to formally adopt the restatement and say, Northwest Airlines was great for the time that it was decided, it doesn't apply in the YouTube social media era, respectfully, that would be a decision for the Supreme Court to make as a policy-making court rather than this court.
And in fact, to the extent that the Supreme Court has applied the substantial or most significant relationship approach, hasn't that, I think that they pretty clearly said in Castillo-Alvarez that they're going to apply that test when the issue has to do with both a procedural and a substantive purpose. And I think that appellant was pretty clear in their argument that they're not arguing the procedural aspects of Colorado law. They're only arguing the substantive purpose of Colorado law, which would indicate that the most significant relationship approach is not what the Supreme Court would ask us to apply.
Precisely.
I have a question. So I think that my issue with factor number one has to do with if your client had filed this claim in Colorado, I expect that your argument would have been, my client lives here in Colorado, and this is where most of his friends and relationships are, and therefore his reputation is most harmed in Colorado rather than in Minnesota. And sorry. And I do think that when you look at the federal cases that are starting to wade into, in the internet age, what do we do? In defamation cases, often they say, well, a person's reputation is most harmed in the place that they live. And so is there a reason why we shouldn't think about that in context of the first factor?
I think that weighs in. Again, I would submit that there is some question about whether or not Mr. Quest is in fact a Colorado resident and resides in Colorado. But for the purposes of this
In the
appeal
complaint, is it alleged that he's a Colorado
today,
resident?
yes, and so for the purposes of this appeal today, I'm not arguing that it's not. We would recognize that Colorado meets that second step of Minnesota's choice of law framework, where there are sufficient contacts of both Colorado and Minnesota for global constitutional perspectives, either forms or either law to apply. Also, this court has recognized, and I think this analysis does survive an internet age evolution of society out of Northwest Airlines, where that first factor has less relevance in situations where they're not consensual transactions, where everybody knows in advance what law is going to apply. When we do business litigation, we put a choice of law in most agreements. So our client, the other client knows, hey, if there's going to be a dispute, everybody's agreed Minnesota or Iowa or Michigan law will apply here.
And counsel, I actually agree with you on that point, speaking only for myself. I think that is a correct analysis. But then the first factor, I think, goes to the underlying issue of avoiding forum shopping then, right?
Well, which I think the district court analyzed as the second issue, or the second factor, maintenance of interstate and international order. I think the district court did in fact find that they thought this was forum shopping and that factor did weigh in favor of Colorado law. Do you disagree with the district court's finding on that?
I disagree that maintenance of interstate order supports Colorado law. I see that my time is almost expired. Do you mind if I fully respond to the question?
And sorry, Judge Reyes, if I restated your question.
I want to make sure I'm answering all the court's questions. So I'm going to respond to Judge Larson, your question first, and I'll look to Judge Reyes and make sure that I've answered any questions that he has. We would dispute that the maintenance of interstate order factor supports application of Colorado law. The Colorado Court of Appeals, different divisions, can't seem to agree on what this statute means and what standard apply. This statute, meaning Colorado's anti-SLAPP.
So you're saying there are other cases that have held it's not a summary judgment standard?
Yes.
Okay.
Specifically, Salazar talks, give me a moment. I have 522 Pacific 3rd at 248. That's a pin site for it. But talks about how, the division held, the court neither accepts the allegations as true nor determines truth, but must assess whether the allegations and defenses are such that's reasonably likely that a jury would find for the plaintiff. And then you get into almost the constitutional avoidance analysis that the Minnesota Supreme Court rejected in Leondecker 1, that the language of the statute is not consistent with a summary judgment standard. Judge Reyes,
I would like to, if you'd respond to Judge Reyes's question.
And I apologize, Judge Reyes, would you mind re-asking the question?
Sure, if I can remember it.
I think
I know what
yeah.
it was. It was on the first factor. So I basically, I said, speaking for myself, I tend to agree with you in terms of the business relationships and with respect to the first factor, but I think there's still, case law talks, the NODAC case talks about, you still want to avoid the forum shopping. That's still part of the consideration even under the first factor, correct?
I think avoidance of forum shopping, yes, is a consideration in the first factor. I would agree with that.
Okay, thank you.
Thank
Can
you.
I ask a question? I think you were trying to, at some point, get to the
Think so.
fourth factor. And just to sum up, since your time is done, perhaps you can give us your best argument as to why you believe that factor so heavily favors application of Minnesota law.
Sure, Your Honor, and I will do my best to be brief as the blinking red light grows ever near, or as in fact here. In the Leondecker decisions, this court at first tried to frame Leondecker as a Rule 12 analysis, or frame Minnesota's anti-SLAPP statute as a Rule 12 analysis. Despite the language of the Minnesota statute not being a Rule 12 analysis, the Minnesota Supreme Court said, no, you can't do that. It's not a Rule 12. This court, in fact, recognized, hey, if this isn't Rule 12, it violates Minnesota's constitutional right in a footnote. And I believe it was Judge Connolly's decision in the first Leondecker appeal, or the first Leondecker appeal concerning the anti-SLAPP statute. And Minnesota.
So this was today in the Court of Appeals. Just went live a little bit ago. I mean, it was live this morning, but they just brought it up just a little bit ago.
Supreme Court in Leondecker 2, I believe 2017 decision, talks about how Minnesota has a
And welcome to the channel.
constitutional interest in affording a jury trial right and submitting a claim
No.
to requiring the court to make a determination, which even LSS says that the court has to make under the anti-SLAPP statute, would violate that right. So unless the court has any other questions, thank you, Your Honor.
Thank you. Counsel for Appellant, you have 5 minutes, and there's a little shuffling behind you, so
Thank you.
I'll give you a sec. You can feel free to adjust the podium if you don't want it that high.
I can roll with it.
Okay.
So
No, he does not want to
I want to
lower
address
it.
the what choice of law furthers Minnesota's interest first. Now, Colorado has forged a legal regime that protects its citizens from defamation while refusing to let that value impede on First Amendment rights. Essentially, Colorado has said, you have this much latitude when you're talking about a Colorado reputation. And I don't see how it furthers Minnesota's interests to say that if you're a Minnesota resident, we can strip you of that protection as long as they come and forum shop into Minnesota to get a different result. Should a Minnesotan have weaker rights than a Coloradan when you're debating over a Colorado reputation? I think that you'd be doing the exact opposite of serving Minnesota's interests.
Counsel, can I ask a question? Do you disagree with respondents' argument that Colorado actually hasn't settled on whether it's the summary judgment standard that applies to the Colorado statute or not? And I guess I'll just tip off that where I'm going with this is on factor 3 with regard to the simplification of the judicial task.
Yep.
Are we really going to be sending this back to the district court to have to resolve conflicts in Colorado law here in Minnesota? Because that would seem a challenging task for a Minnesota judge to do.
It would, but fortunately, you don't have that problem. His assessment of Colorado law, with all respect, is wildly incorrect, not even close. And the case he cites for that proposition is a California case. So California, looking at the California
So
anti-SLAPP law.
can you just, so the case that you're citing for the summary judgment standard, can you just explain, is that what we would consider here in Minnesota a precedential decision that's binding on all the courts, or is that, just because I don't think
is.
you cited to the Northwest Reporter, so I wanted to, is that a binding case on all the courts, or is that a non-precedential decision that's more advisory? Because here in Minnesota, we would have a distinction in terms of the weight that we
Right.
would give to that kind of case. And so I guess the case that you're relying on, what is the weight of that authority?
It is the most recent appellate decision out of Colorado on it. So I guess you'd look at it like if you were in a federal court, the federal court would have to follow that. So I don't think we have
The
any.
district courts in Colorado would have to follow the decision that was,
Yes.
okay, thank you.
And as far as simplifying the task, I think I didn't give a very satisfying answer to Justice Eade when you asked me a question. And really, it was so fundamental. The predictability factor, simplifying the task. Remember, there's all this discussion of, well, why would you think that a Colorado reputation would be governed by Colorado law? Well, Calder versus Jones out of the United States Supreme Court made that very clear. Now, that's a personal jurisdiction case, but the reason that personal jurisdiction was in California in that case was because the Supreme Court said, the United States Supreme Court said very clearly, your reputation is where you are. Unless there's some overwhelming reason not to be. Like I could see maybe if Stephen King.
Can you remind
lives
me
in-
the year of that case? Is that a case from the internet age? Because I think respondents' argument is that this person's reputation is really on the internet. And so where his reputation was harmed was globally or across the entire United States, and that is his
let's adopt-
reputation is no longer really located in Colorado, given this particular person's lifestyle.
Well, then let's adopt that. Then why not Hawaii law? Why not California law? Why not Massachusetts law? I mean, I think that we have to have some predictability, and that predictability is, when I do pre-publication review for publications, they come to me and they say, we're going to write this story, and I say, where does the subject live? That's how everybody I know who does pre-pub review does it. It says, where are we going to wind up getting sued, or what state law are we going to look at? So predictability, I think, at least in the online publication world, would be thrown into chaos in Minnesota if we decided that somebody whose reputation is everywhere but lives in a specific place, that their reputation should then be managed under Minnesota law. And remember, again, if he sued at home, it would be a different result. So Colorado law needs to apply here unless you would like a different result for Minnesota residents, which again strikes at the core of what Minnesota's interests are. I think Minnesota's interests, if anything, should be that its people are free to speak in the same way that everybody else is, not to say that they're going to wind up getting sued in a libel tourism case by somebody who comes from one of the 35 anti-SLAPP states. And again, to remind you, I'm sorry, I'm done. If you have any questions for me while I'm still up here.
Thank you.
All right, thank you very much. And thank you, counsel.
Thank you to both counsel for your arguments in this case. This case has been submitted, and we will issue an opinion in the time prescribed by statute. Thank you.
All right. Cool. I think I got the remote on. The remote on? What am I talking about? The microphone on. Anyway, I think the last sentence there was very indicative of what the problem is. The problem is that this is not an issue for court. This is an issue for the legislature. The legislature is the one that writes the anti-SLAPP laws. And as of right now, so let's play devil's advocate to the closing arguments. You're also, it's something like, Minnesota citizens can be sued by these people that have these anti-SLAPP laws, and so they can leave that state and sue people in Minnesota. Yeah, but you are, as a citizen of the state, you are subjecting yourself to the protections of that state. So, see, that is, again, it goes to the legislature needs to fix this. It's not something that's already written. It's not an issue that's come up. It's like saying, well, all the other states are doing it, so we ought to do it. You ought to do it here too. I don't know if that's the strongest argument. I don't think, I don't know. I don't know enough about trial stuff. I guess, no, I don't, I'm not a trial guy. Not a trial guy. You want to talk about government? Yeah, that's why I told you. It's the legislature's the one that should answer this, not the courts. But it's in their hands now. I think both sides They had strong arguments. I think the guy, he's supposed to be somebody famous or something. I don't know. There's no such thing as a famous lawyer to me. Well, I take it back. Johnny Cochran. We all love Johnny Cochran. But anyway, oh, let's see here. Let's see what you guys think. Hang on, I take my earphones out finally. God, man, this thing's, every once in a while they hit a pitch when they're talking. It makes my ears tickle. My eardrums tickle. You guys ever have that problem? No, I didn't think so. Anyway, let's see here. Hey, there's several people here I want to welcome in here. So if everybody is true, one, I want to say, hey, Sally, how are you doing? Sally Talks. Those of you that don't know Sally, we became friends over on Twitter. We have a lot of the same views on things. And it's funny how that I don't know, just kind of came about, but she's a good person. So anyway, check her out. We've got, if this is true, hey, Drex, how you doing, bud? It is a pleasure to have you here. And everybody say hi. Give him a warm welcome. Let's see. I know I missed somebody else. Who'd I miss? I don't think I said hey to Cheryl. Sorry, guys. You guys know that here I love you guys, and so I don't want to miss anything. So anyway, what do you guys think? That's cool, man. That's cool. Oh, by the way, hey, I actually have a story for you, Drex, if this is Drex. So you met our buddy Valhalla in Nashville. Jessica, before Valhalla got back, Jessica Reloaded had already told me that you asked her what his deal was. And I told him, I said, Valhalla, evidently you have a thing with thighs. You run up to large black men and start rubbing their thighs. And he looked at me. He didn't know what's going on. He's like, maybe I did do that. So anyway, you don't know me and anything like that. But anyway, you have been a lot of conversation for us. Valhalla is a good real life friend of mine. Lives right down the road, and we get to hang out. Matter of fact, if anybody sees Valhalla, tell him that my wife said that there's too much beer in the refrigerator and somebody needs to come over and get rid of it. True words. I'm not making that one up. Yeah, he gives hugs inappropriately. Toy Box Brain, how you doing, bud? Nose or no nose? Oh, let's see here. Yeah, okay, yeah. It's you, and you did me, Valhalla. Yeah, man, that was the craziest thing, dude. It was hilarious. The look on Valhalla's face, guys. And I know, see, this is what I love about this whole experiment here we're doing on the worldwide tubes. Al Gore's internet. Thank you, Al. Is that we get to have these experiences and stuff. Like I had never thought in a million years I'd be able to share a Valhalla story with Drex. So that's cool. Even though the underlying thing here is that we have a conflict here. I don't like conflicts. Okay. There was a professor one time, she had a thing called therapeutic jurisprudence, and other professors made fun of her. And I liked what I didn't like the professor so much as I liked what she said about it. It took a while for me to understand. And it was that we oftentimes, especially like corporate law, that's where her background had been in. In corporate law, they're quick to file suit, but they're slow to resolve the issue. And that's what I think, I think that's a problem. with a lot of stuff in America. So, and I like, I like guys. I like everybody. I don't cause I don't cause beef. At least I try not to. Some people think I'm a bottom feeder. That's a new thing going around. I was like, that's awesome. I'm finally getting some hate mail. That's cool. But anyway, no, it's man, I don't know. It's not cool. What I'm interested though here on this the most is that it's the nerd part of me is how does this affect the law? And I think that this is a very, very good academic source. We're going to see things that if for the nerds, it's going to change things forever. Now, what does this mean to y'all? Nothing. It's not going to change anything, I don't think. At the end of the day, you know what? Maybe 5 years from now, everybody will be talking about, oh, yeah, I remember when that happened. It was a clash of titans. And it's over with. Hopefully at the end of this, everybody is better off. But as of right now, man, it's oh man, Dave, I just saw that. Guys, talking basketball here. Y'all know that I'm a University of Tennessee alumni and fan, but the Auburn's basketball coach is a former Tennessee coach. So anyway, let's see here. What else have you guys got? Anybody have anything they wanted to discuss about this? Anything you want to say? Now's the time to do it. Let's bring it all out. You guys know personally where I stand. I like Nick and I like Monty. And because this is the way I am. The way I am is that if somebody, I don't care if you have beef with somebody else. It's how you treat me, how our relationship is. Because I don't pick sides. I don't want to be in the middle of two people's arguments. I lost someone who I thought was a good friend. I think over a misunderstanding like that. Fair and balanced. I still miss her. I miss what we had. Matter of fact, I saw her picture pop up on a search I did today, and I thought, wow, that brings back memories. But anyway, yeah, I don't have a thing in this. I do think it's good though for us to talk about it, and know at the end of the day, I want the best for everybody. So I still don't get anything. I figured that I'd be getting some hate talk from you guys after that. You want me to go play some more Alyssa clips? Let's see here. So half hours. I've always thought it was dumb and Monty should drop it. What if he would have dropped it if Nick would have apologized? I don't know if that's the case, but I'm asking that question. I'm playing devil's advocate. I'm trying to get you guys riled up, get you guys, and make you mad at me. That's what I'm trying to do. Nothing else is working. My algorithm is stale, as Ozzy Overlord would say. He's tired of his algorithm. I don't know. Yeah, no hate. Half hours. I actually was going to do another cover the Ethan Van Sciver stuff that's going on. He's got some more things happening, and by the way, he is looking for. Look at this. M. Young's been here for a month. I've definitely been here longer. So, is that good or is that bad, M. Young? Does it feel like a long time? Are you ready to leave? Is that what you're saying? I'm glad to have you here. You know that. Traveling Fools, how you doing, bud? I want us to get together this week. What day is today? Today's Wednesday? Oh, yeah, tomorrow's the 29th. Yeah, that's when I said, hey, listen to this. I said I was going to do a drama stream tomorrow because I don't do drama. But it's the 29th, so it happens once every 4 years. I will do a drama stream. So if anybody has any drama, we're going to do it tomorrow. I'll do like a real long stream. I don't know how or what, but it'll be it. Oh my gosh, Fallsworth's been a member for 13 months. I obviously have no life. He doesn't. Fallstorm, not this weekend, but the following, not this Friday night. Oh, geez. Yes, I got to work on Friday Night Live. Guys, Friday Night Live this Friday. Be there. It's going to be awesome. I'm going to need to talk with Steve Gosney. He's launching his book the next day. And so I want to really do a big pump up for him and for his book and stuff. And also, not this Friday, but the following Friday will be the second anniversary for Friday Night Live. So everybody, please come out. We'll have a good time. It'll be great. Okay? It'll be a good time. Let's see here. Sorry, that could be misinterpreted. No. It's not. It's not. Yes, I like Miami Spice. Congratulations for making it a month. Once you're here a month, you can't leave. You know that, right? Oh, never apologize. Yeah, he does. Oh, okay, so that is true. And I agree with that too. Oh man, come on. This has got to pull up. Oh, it won't pull up, will it? Oh, come on. Come on. Where is this? Why is this late? Why is this late? Anyway, if I see it, I'll pull it up. McDowell podcast, the end of Black History Month. I'm going to bust 29 nuts. Dude. Acorns. He's talking about acorns. like a Florida police officer. Oh my gosh, you saw it. Yeah, so I do adhere to that. Do not apologize. So that happened during the whole woke movement, right? No, don't apologize for what you said, for your thoughts. Okay. But when you come to this, where I'm saying apologize, is just be like, I don't know. I don't want to, I'm not speaking for Nick. I'm not speaking for Monty. I'm thinking out as a counselor, trying to avoid conflict. What do you say? Say, hey, listen, I didn't mean to upset you. I won't do it again. I mean, just there's a. I don't have a good way of saying it. I apologize. I don't have a good way of saying it. Yes, I feel conflicted right now because one, I say, you just apologize for it. Well, okay, you have to be sincere for it to be an apology. You have to truly mean that. I goofed on that, right? But it's the yeah, I see yours. Now yours came up over here, but yeah. Drex didn't. They didn't come up. Drex didn't. He couldn't get his eggplant up over on the StreamYard chat. Drex, you need help with that eggplant over here on StreamYard. They didn't like it. Oh gosh. Yeah, no, that's true. That's true. Here's the thing. Don't, and I couldn't imagine being monograph in this situation. It's not, I don't know, guys. This is the problems we have with going out here and doing this thing. This is an entertainment deal. This is the entertainment of the 21st century. I don't think anybody was expecting this to happen. Okay, I think the Panda Express lockdown, we had a couple of years ago, right? I think that changed things where people weren't ready for it. This is how people want to get content now. This is people want to have they want to see people talk and have opinions about things. It's talk radio, but it's not talk radio. Does that make sense? It's instead of being localized to an area where like you have like the local news, well, now you got the local person, no matter where they are in the world, they're local to you. Like I am talking right now to Miami Spice, in Miami. Hey, Mrs. K. Griffs, how are you doing? Is this a no to me? What did so I missed that. Yes, this one does. Yes, this one does. You know what? Here's the thing. At the end of the day, you know what I'd rather do? I'd rather have eggplants and raindrops emojis. That's what I'm into. I think I'm into having fun. I'm into spreading the love and seeing all of us grow. I know I'm the eternal optimist, which is so weird. If you ask other people, they say, no, you aren't. You guys have made me change. And I see now things in other people's perspective. And I think I don't want to see anybody hurt. I don't want to see anybody hurt. Which is, what's going on here? You guys are killing me with that. I need to stop reading chat. Wait a second. You told me I don't read chat enough. Oh, okay. Thank you. Thank you. Spread love like an R. Kelly skit. You don't want to spread love like R. Kelly. You don't want to do that. But you do need to spread love. It is man, it's what we're here for, It is. It's God, man, you guys know I like to laugh and have a good time and everything, but I hate to think that something I say hurt somebody's feelings or something like that. It's a responsibility. I don't have to have it. Nobody does. But gosh, man, this whole thing's sickening because you see it in creators, and I love these guys. I do. I wish everybody the best. Okay, so let me tell you something, man. I put out the other day, I put out a tweet. I said, it's not about the history of something. It's the politicalization. It's a political month. And next month's going to be another political month. And next month's going to be another political month. Their divisive their divisive politics created by people that get power out of divisiveness. And the best thing to do is to ignore it. And I wish that I hate it being spoon-fed to us. I do, because I don't think it brings us together. I think the best way to bring us together is that we all look and we all go, hey, we're all God's children. We are all the product of our creator. whoever your creator is, we are the product of that. And we are all, for the most part in here, we're all Americans. And we need to start acting like that. And because America, we are the exceptional people of the world. We are the world's unwanted children. And what have we always done because of that? We kick ass all the time. And people don't like it. So that's it, man. American history. And you know what? Here's the deal. American history has good parts, it has bad parts. But it was at the same time, everybody was suffering during those parts. You know, when the Declaration of Independence was written and signed, if you go through the bar tab for the Independence Hall, then those guys were hurting so bad the next day. But no, it's everybody hurts, and it's all about it's American exceptionalism, and that's what I think is great about everybody who wants to come here. We are God's unwanted, or God. We are the world's unwanted children, and however we got here, I'm glad you're here. Okay, it's nothing happened in the past that I care about to affect the way I feel about you in the future. But, I do want to say, oh, wait, I don't know how to say things. Well, that sucked. I messed up my screen. God, man, I really have got to stop pushing buttons.
Hi. Fox. Thank you. Hey, what's up, Al-Qaeda?
2 drink minimum. Thank you so much. How are you doing? Don't know you're a guy. That was the first thing I hit. And I was like, well, I'm just going to let it play now. 2 drink minimum. I love seeing you come around. Yeah. I was thinking the other day of some of the, I think I said this last time. I was like, you're one of the longest supporters of my channel. And I appreciate you. And I always feel like I'm doing good when you come on in. So thank you. Cheers to you, 2 drink minimum. Whoops, I hit my mic. Boy, I'm just full of it tonight, aren't I? Maybe I need to stop drinking Diet Coke. Oh. What'd you do? What did Volstorm do? I need to stop reading the chat. Oh. Put your keys in the fishbowl. Oh, look at that. Vols win. Congratulations. I don't have a good Vols win. Whoops, I did get rid of the chat there on that, though. Wow. I'm just doing so wonderful today. Oh, look at this. Vols win. There we go. Boom. So I got rid of the chat again. What am I doing, man? Guys, oh, hey, one other thing. I want you guys to know. So MG Law, our buddy MG Law, he is 24. Last night, he was 24 subscribers away from 1,000. I'm 40 away from 3,000. I'm dying to get it, right? I'm dying to get it. But don't forget MG Law. I want to help him get over 1,000. That's a major milestone for him, and we all love him. He's a great guy. And he will be at the Friday Night live event, May 17th. Drex, if you're here, where there's a long story going on with this channel. I said that my goal was for us to have a Vegas meetup, and that was when I think I got like 500 subs, like 2 years ago. Well, then Rekieta had a Vegas thing, and I was like, he stole it from me. No, he doesn't know who I am. At the time, I don't know if he does now or not. We talked one time on Reloadeds, but that's a long story. Anyway, so we are doing a live thing, though. But it's at Dollywood, like good Tennessee rednecks and everything would be, right? Dollywood. Going to the Twin Peaks of Tennessee. MLS was instrumental in getting that started. Actually, I invited him on tonight, see if he wanted to cover this. He is, because he's a dang good trial attorney. What did I miss here? Hold on. Traveling Fools, YouTube milestones are fun to meet. Yes. Yeah, they are, aren't they? They really are. Yeah, Traveling Fools knows. Traveling Fools had a incredible channel that YouTube and him, or they had disagreements on monetization, and he has recently been monetized, which is wonderful, wonderful. And this guy is a cool, laid back deal over there. You guys got to check out Traveling Fools. We got to get together soon. You know what? I need to start sending messages and responding to messages. That's my problem. I've got a lot of problems. That's just the beginning of them. Just the beginning of them. Yes. Yes. Hey, man, thanks for stopping by, brother. Appreciate you, man. I hope one day to give each other a hard time in real life. Guys, there's a MGTOW podcast, Drexel. So go give. Oh, wait a second. Does he have a channel? I keep saying him as being a podcast. Yeah, be sure you're subscribed to Drex. Oh, yes. Yes, Texas Jen can finally drive the bang bus. Do you have the bang bus in Tennessee? Oh. Yes, there we go. Thank you, Miami. I don't know why I didn't think anything about that beforehand. I'm a horrible host. That's why. I'm a horrible host. Oh, well. Guys, that was a hoop. What do you guys want to do next? Because I ain't got nothing. I'm out. I'm completely out. So the Court of Appeals, they'll rule on it. It'll be out. Why can't you be in Dollywood? I want Rabbit there. All right, so now 7 Pike and Gutters Pub. You guys have got to talk to Texas Jen. She's like the David Lee Roth of the Bang Bus. Miami Spice. What happens next is that the Court of Appeals will decide on it and then send it back down to the lower court on whether or not what jurisdiction should apply. And of course, though, there's 2 questions: what jurisdiction will apply to this? And actually, there could be 3. That it's forum shopping and probably maybe kick the whole thing out. But it doesn't mean it's over if it gets kicked out. Weird, right? And then the other thing is that it gets sent back down and says it has to have discovery before you can go forward into this motion. That was one of the things they were talking about. So, yeah, we'll see what they decide, but that won't be for probably a couple weeks, I would imagine. They take their time on appeals. So, oh well. Well, I don't want to hear this, Rabbit. I don't want to hear that at all. We gotta get you we gotta get you healthy. Okay. So anyway, guys, I don't know, man. I'm stuck right now. I'm stuck. I'm very humbled and honored. Had Monograph and talk with Sally and Drexel here. All are people that I admire. Most importantly, Traveling Fools and Volstorm. All my friends too. You guys really mean a lot to me. And yeah, and I don't know. You know, it's after seeing all this happening today and seeing the controversy it causes. Here's something I don't want you guys to do. I guess this might be my ultimate thing. Please do not treat this like it's a team sport, okay? Because these are creators, these are people that just they put on their pants one leg at a time. At the end of the day, they have a following that likes them. As a team sport, I don't know, man. Just don't think it's like your guy versus that guy. Both let the courts just do their thing. Okay, it's out of our hands. So this is why I hate covering trials, guys. This is why I hate covering trials. I did a story one time about a girl who was beat to unalive by her boyfriend. She was from Washington State. They're down in Mexico, and I had her aunt, supposedly her aunt, left a message saying, you know, like, how dare you talk about her and all this other stuff. So I don't know, maybe I did like another one. I'd done like 3 or 4 stories following up on this. So I had the one where the aunt left something. And then like 3 months later, I had one of supposedly her mom that said, thank you for covering this. I don't like being in the middle of things like that. You know? I don't like that. That's how this is. I don't like being in the middle of something like this. And that's why I'm like, let's just stick to the facts of everything. I think Monograph is in the right jurisdiction. I think that because the way we were taught is that you can always sue where somebody lives. You always have that where the defendant lives because they're the one that's out the most, right? You don't want to make the defendant travel to you. So you're the plaintiff and you go to the defendant. You've got standing. I mean, that's just first year law school, man. What happens next? I don't know. I'm trying to understand everything they're trying to say. It was a very remember for a lawyer, a pen is their paintbrush. Okay, they are an artist with words, and that's the part where I try to listen. And one thing I get carried away because I'm like, oh, that's really good. Like I'm very impressed. That's why I like Steve Gosney so much. He's probably one of the smart. Him and Branca are the 2 smartest people I can think of recently. I've talked to in the field of law. But I try to just like interpret it, and when I pick up on things, that's why I wanted to stop in and show you guys. I don't know. I do hate those. I do hate that. Let's see here. Made a snowshoe rabbit taco. Oh, really? How to pop out to feed guineas, emus, turkeys, and chickens? Wow. Wow. 907 Pike, Alaska. That's what we need, some videos. Emus in Alaska? You know what I want to do? I want to get some penguins and take to the North Pole. See how they do. I know it's awful, isn't it? I just think it'd be funny because, okay, so like when I was in the third grade, I went to Memphis Public Schools, and in the third grade, there was a teacher that said that polar bears hunted penguins. They're not even on the same part of the earth. They're on the opposite poles. That's my good education. Yeah, wouldn't they? No, penguins are my favorite. Polar bears will eat them up. Are you a penguin person because of the penguin march? You know, birds aren't real, right? But the drones I like are the flamingos. I dig flamingos. And I don't like pink, but pink likes me. Oh my gosh. What? No, I'm not going to wear pants. Actually, I am wearing pants right now. I was late getting this started. Oh my gosh, half Irish. I'm a penguin person. Pre-March of the Penguins. I had an imaginary best friend penguin when I was a kid. Half Irish. Are you Billy Madison? That would be so cool if you were Billy Madison. I love that too. I think that's awesome. Oh, you're not Billy Madison? But do you get the reference? Please tell me you get the reference. Oh my gosh, I need to do a movie night. Elaine and Dot, I saw you were streaming. You were streaming earlier. I was trying to get in there. I was trying to set up a stream. I was trying to do, then I had to go do dinner. How dare I have 3D life get in the way? Guys, this is Hot Damn Elaine. Don't let the name change fool you. It's Hot Damn. Oh my gosh. I think this is what we're gonna change her name to. Miami Spice, the Spicy Mama. Billy Madison. Be awesome. Yeah. Earlier today sucked. It was bad. It does suck. What is this? Graham Norton, Benedict Cumberbatch saying penguin? There we go. Okay.
the show. We get. Not if I don't.
Okay.
So obviously, when will we see more Sherlock?
2015, I think. Yeah.
Okay, are you in the next Star Trek?
No comment.
Okay. Are you in news?
Okay, hold on here. I gotta fast forward this. I'm gonna get a ding.
Very like what you did.
Oh God. Do you want me to do that as well?
If you can.
So, Miranda.
No.
Let's have a look. Listen carefully.
And the last thing you might expect to see here is
Oh.
penguins. These
Is what?
are Fiordland crested penguins, named after this corner of South New Zealand. So why are these woodlands so attractive to penguins?
What's he? I don't get what he's saying. He's saying it right, isn't he? Oh, pinwings. Oh, I gotcha. Gotcha. Okay. Oh, I didn't realize that. So, I'm not that impressed with him. Everybody thinks he's a great actor. I don't think he's that good. I can't think of anything he's been good in. He was a horrible con. Good night, Rabbit. Well, he's a K-pop fan. Benedict Cucumbers. Never mind, I can't call it that. Anyway, guys, I don't know. I'm at a loss now. I'm gonna go jump. I'm gonna get out of here. I'm gonna leave you guys alone. Let you have a good, beautiful night, guys. Please, we gotta help MG Law get to 1,000. Okay. Oh, it keeps getting worse. I'll have to go back and listen to it, but I'm not worried about it getting the Strike-a-Rooney. Oh, I say penguin. What is it? It's a penguin. Penguin? Yeah, it's penguin. Pinguin. I don't know. Damn tuxedo birds. Oh, look who just came in here. How'd you get over that? How did that happen? Dude, the bot subs, they won't last. Oh, dude, you can't. I'm sorry. Yeah, don't buy subs. All right, so we're back on me then. I need 40 before FNL. Yes, you do. You do. They'll evaporate on you. You won't even realize what's happening. Love Megan Fox. That's awesome, G-Love. I do too. But it's pronounced Megan. Megan. It's spelled Megan, but it's Megan Fox. Oh, wait. Are we talking about somebody different? My love is Megan Fox. Lefty, how you doing? Yep. Unless you are Drex. Oh my gosh, dude. Oh my gosh. Oh, she's a nut. Wolfkinder's been a member for 13 months. Are you unsubbed again? So here's what's weird about that, Wolfkinder. So I've started, like, I've been watching YouTube at night. Eve Van Skyver's Trash Cast has been putting me to sleep. Because it's like 3 hours, 4 hours long. And I just hit the button, right? But every time I do it on TV, it says I'm unsubbed. It's the weirdest thing. I thought about you the other day. I was like, this is the third time I've done it. But yeah, it has to be over 20 times you've been unsubbed. Dude, you need to give him a high five. That's what I'd do, Lefty, if I were you. Go give Drex a high five. And take him a sandwich. People like sandwiches. I had tacos tonight. Speaking of sandwiches. I'm not a Jersey Mike fan. I like Lenny's. Oh, or Publix. I like Publix. But Lenny's is really good. Excuse me. See what happens when you don't sit properly? Gosh. Yes, thank you, Now 7 Pike. I appreciate that. Oh, thanks. Jen loves Jersey Mike's. Yeah, I mean, they're good, but everything Publix is the best. I gotta take you to the Kroger I found. It's Miami Spicy Mama. It's huge. It's a huge Kroger. Biggest Kroger you've ever been in. Ugly Truckling's at Taco Bell right now. What was the last thing I got at Taco Bell? I can't remember. I do know I love their Mexican pizza because they take it away. They take away all the good stuff. Oh, by the way, did you guys see that Wendy's is going to do a all digital menu? And they're talking about they're going to increase prices during peak hours. So here it is. It's rush hour, lunchtime, right? Everybody gets out. They all run to Wendy's to get a delicious Dave's burger. And they raise the price by $1. What about that? Is that not crazy? Yeah, they brought it back. They brought it back across America. Yeah, when did they? Dude, that is such a issue of contention for people. Such an issue of contention. Now they're saying they're absolutely not going to do that. Yeah, that means they're going to do it then. That means they're going to do it. I have not gone back to Sonic since I found out that I was supposed to tip the people that bring you your drinks. I was like, I'm here at happy hour. I'm getting a half price drink because I'm poor. And I'm supposed to tip on top of that. And I hadn't tipped all this time. Oh, so I stopped going to Sonic. Stop going to Sonic. I need to find a Sonic with a drive-in. Some of them have those. Y'all need Heb? Blows Publix away? I really thought I was going to read something dirty when I figured out what that meant. Oh, yes. The White Rabbit loves tater tots. Sonic has drive-through windows now. See, I need to go there. Yeah, definitely the drive-through. It's like Jeb, but Heb. Oh, the Sonic still have those chili pies? Dude, what a stupid thing. Oh my gosh. It's like, oh, hey, I want some corn chips, and some chili out of a can, and some gooey cheese on top, and some jalapenos, because that's going to make everybody in the car happy. Oh, geez. I got a taco salad this weekend. Wendy's reintroduced them. There's a ladybug in your lettuce. So how's that work? Ladybugs are supposed to be good luck, but a Frito pie. We have a what's that place here? They have East Tennessee. Petros. They're good. Why am I running out of oxygen? Maybe it's because I have the door closed. I have pants on. Pants suck the oxygen out of you. Did you know that? I'm going to go to Taco Bell, get a chili cheese burrito. Do they still have them? Then go to Chick-fil-A and get an original. Then put the chili cheese burrito inside the chicken sandwich. I don't see why that wouldn't be good. Lefty, take a picture of it. Their concoction. Oh, that does sound good, though. Yeah, so do you get taco sauce and put on there, or do you get like Chick-fil-A sauce and put on there? Like barbecue or honey mustard or something like that? Sonic chili is for mad dads on road trips. I do not know of Burgerville, but Dairy Queen. Dairy Queen had Dave, they had Dairy Queen made like all the mom and pop owned Dairy Queens. Like these places, like small towns, geez, I don't know. This was like 10 years ago, maybe something like that. They all had to, I don't know when it was. I'm just making up a year. Okay. So, but Dairy Queen corporate said, look, we're redoing all the Dairy Queens. You as a franchise owner have to invest like $300,000 on a building. And all these again, it's small town Dairy Queens. And they're like, no, I don't have that. So everything became like Dairy Barn or Dairy Good or something like that. And they kept their buildings, but they yeeted out the franchise. And so you go like these small little towns and you'll see something like, well, that looks like a Dairy Queen, but what the heck is Dairy Bob's? And what's funny is I love them, man, because I'm just like, oh, yeah, it's the little guy making their way. Chili cheese chicken. Ooh, that's a good idea. Just the chili cheese is good enough. No sauce. Yeah. You're thinking like I care. I don't care about NBA, dude. I'm not a basketball guy. I like college football. That's it, man. Oh, I didn't even know Memphis still had a team. Are they still playing in the pyramid? That's how little I know. Sad, isn't it? Sad. Oh, geez, guys. Well, listen, thanks for coming here. Thanks for making this a successful chat. I enjoyed everybody who came by. You guys are awesome. Okay. And, I don't know. Tomorrow will be fun. I'll see if I end up doing that drama. It'll be stupid if I do, because I can't. I get like halfway into something. I just can't do this, man. I'm not into that. I want to see people. Yeah, it is. It's a huge Bass Pro Shop. Can you believe that? You can spend the night in there. It's a hotel too, and there's a restaurant on top. There's also a crystal skull hidden in the top of the pyramid, and Alex Jones found it. That'd be weird. I wouldn't know what to think. What's his name? Rick Barnes needs that. He's never gone past the Sweet 16, has he? I'm out of drink. Love you guys. Thank you so much. And now more than ever, we need to dance.
Well, I woke up to go get me a cold pop, and then I thought somebody was barbecuing. I said, oh, Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Well, I woke up to go get me a cold pop. Then I thought somebody was barbecuing. I said, oh Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. Jesus, 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 it's a fire. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. Jesus, 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 Jesus. Ain't nobody got time for that.